Hey everyone, welcome back to the Deep Dive. Today we're going to be taking a look at something that affects pretty much all of us in one way or another, and that is premises liability.
Yeah.
And, I feel like this is something that we hear about kind of in passing.
Mm-hmm.
We hear the term, we kind of have a vague idea, but I don't think a lot of people really know exactly what it means or how it applies to them.
Right.
So maybe we could start there. What is premises liability?
Well, you can think about it as the body of law that covers injuries that happen on someone else's property.
Mm-hmm.
So like if you slip and fall at the grocery store,
Yeah.
that would fall under premises liability.
Okay.
And it really comes down to, the idea that property owners, they have a legal duty to keep your property safe for visitors.
So it's not just about accidents that happen inside a building, right?
Right.
It could be like a parking lot or even, a sidewalk outside.
Exactly. It applies to pretty much any type of property you can think of.
Yeah.
Homes, businesses, even like parks and public spaces.
Okay, got it.
But here's where it gets a little bit interesting.
Okay.
The level of responsibility that a property owner has, it actually depends on your visitor status.
Oh, okay. So what do you mean by that?
So the law recognizes different categories of visitors, and the duty of care that a property owner owes to you depends on which category you fall into.
So it's like different levels of VIPs.
Kind of like that, yeah. So you have your top-tier visitors, your VIPs. Legally speaking, they're called invitees.
Invitees. Yeah.
And these are people who are on the property for a business purpose or because the property owner specifically invited them. So think customers in a store, patients at a hospital, someone attending a concert.
Right.
Those are all invitees.
Okay, so they're kind of there for the mutual benefit of both parties.
Right, exactly.
So they have the highest level of care that's owed to them.
Exactly. Property owners owe the highest duty of care to invitees, which means they have to actively inspect for and fix any hazards. They got to make sure things are safe.
Makes sense.
Then you have your second-tier visitors, the general admission folks. Those are called licensees.
Licensees.
And these are people who are on the property with permission, but not necessarily for business purposes. So think of your friends coming over for dinner.
Okay.
Or a neighbor borrowing a cup of sugar.
Got it.
They're on your property with your permission, but they're not really there for any kind of business transaction.
Right.
So in those cases, the property owner still has a duty to warn licensees about any known dangers, but they don't have to go above and beyond to discover hidden hazards.
Okay, so it's more like, hey, watch out for that loose step I've been meaning to fix.
Exactly. Yeah, you got to give them a heads up about anything you know about.
But you don't have to go and hire a safety inspector before they come over.
Right, exactly.
Okay, makes sense. And then I'm guessing there's a third category for people who aren't really supposed to be there in the first place?
Yeah, those are our trespassers, people who enter a property without permission.
Okay, and so what kind of duty of care does a property owner owe to a trespasser?
Well, obviously, they don't have to roll out the red carpet or anything like that. But they can't intentionally create hazards to harm trespassers.
Okay.
And they can't ignore obvious dangers that a trespasser might encounter.
So no setting up booby traps.
No booby traps.
Got it.
But yeah, there's still a basic level of legal protection even for trespassers.
So even if you're not supposed to be there, there are still some limits on what a property owner can do.
Exactly. It all comes back to this idea of reasonable care.
Okay, I see. So that's the breakdown of the different visitor categories,
Right.
and how the duty of care changes depending on who you are.
Exactly.
Now let's talk about the actual injuries. What kind of things are we talking about when we say someone's injured on someone else's property? I mean, is it just slips and falls, or is there more to it than that?
It's actually a much wider range of possibilities than you might think.
Okay.
You have your classic slip and falls. Those are still very common.
Mm-hmm.
Wet floors, icy sidewalks, loose rugs,
Right.
things like that.
The banana peel scenario.
Yeah, exactly. Banana peel happens.
Yeah.
But then you also have things like uneven pavement that can be a tripping hazard, especially for older folks.
Okay.
You have inadequate lighting in a parking lot that can create a dangerous situation. You have broken stairs, faulty elevators,
Right.
even like objects falling from balconies.
Yeah.
All of these things can fall under premises liability.
So it's not just about what we traditionally think of as obvious hazards. It could be a lot of different things.
Exactly. And the thing is, some of these hazards can be surprisingly dangerous. Something that you or I might not even think twice about could cause a serious injury to someone else.
That's true. I might be able to easily navigate a cracked sidewalk, but for someone with mobility issues, it could be a real hazard.
Exactly.
Yeah.
So it's be aware of your surroundings and think about potential dangers no matter where you are.
Okay, so we've talked about the different types of visitors, and we've talked about some of the common hazards.
Right.
Now, let's say the worst happens and someone is injured on someone else's property. What should they do? What's the first step?
The absolutely first thing you should do is report the incident to the property owner or manager right away.
Okay, so don't just try to walk it off.
No, definitely not. And here's why: it creates a record of the event.
Okay.
It puts them on notice that something happened.
Got it. So they can't claim later on that they didn't know about it.
Exactly. And documentation is key here, too.
Okay.
Take photos or videos of the hazard that caused your injury.
Okay.
If there are any witnesses, get their contact information and, of course, seek medical attention as soon as possible.
So gather as much evidence as you can right from the start.
Exactly. The more evidence you have to support your claim, the better. And speaking of claims, there are deadlines for filing these types of lawsuits.
Okay.
Those are called statutes of limitations. So don't delay in seeking legal advice if you believe you have a valid claim.
Okay, so report the incident, document everything, seek medical attention, and talk to an attorney if needed.
You got it.
Got it. Now, this all seems pretty general. What about more specific situations, like let's say you live in an apartment complex? Are there any unique factors that come into play with premises liability in those settings?
Absolutely. Apartment complexes have their own set of rules and responsibilities. And the question of who's liable for what can get a little bit trickier when you're dealing with shared spaces and multiple tenants.
Okay, so it's not as simple as saying the landlord is automatically responsible for everything that happens on the property.
Right. For example, if you slip and fall in your own apartment because you spilled something and didn't clean it up,
Right.
that's probably on you, not the landlord.
Okay.
But if you trip on a broken step in a common area like a hallway or a staircase,
Yeah.
and the landlord knew about it but didn't fix it well, that's a different story.
Okay, so it comes down to where the injury happened and whether the landlord had a reasonable chance to address the hazard.
Exactly. And that's where your lease agreement comes in handy, because it often outlines who's responsible for maintaining different areas of the property.
So if my lease says that the landlord is in charge of maintaining the walkways and I trip on a cracked sidewalk, I'd have a stronger case.
Most likely, yes. But again, it's always best to consult with an attorney to discuss the specifics of your situation.
Okay, this is all incredibly helpful. I feel like we're already starting to peel back the layers of this whole premises liability thing, and I think a lot of people probably don't realize how complex it can be. But before we wrap up this part of our deep dive, I have one more question.
Yeah.
Are landlords ever completely off the hook when it comes to tenant injuries, or is there always some level of responsibility there?
Well, that's a great question. And as with most things in the legal world, the answer is it depends.
Figures, give me an example. When might a landlord not be held liable for a tenant's injury?
Well, like we were talking about earlier, if a tenant is partly responsible for their own injury because of their own carelessness,
Yeah.
that can definitely impact the outcome of a case.
Right.
If a tenant leaves a skateboard at the top of the stairs and trips over it, the landlord might not be fully liable in that situation.
Okay, that makes sense. There's that shared responsibility piece.
Exactly. And what about those situations where a tenant's injured because of something the landlord didn't even know about?
Right.
Let's say there's a hidden electrical problem in a tenant's apartment that the landlord had no way of knowing about, and the tenant gets electrocuted. Well, in that case, it might be very difficult to hold the landlord liable, especially if they've been doing regular inspections and responding to maintenance requests.
Okay, so it's not just about what happened, it's also about whether the landlord knew about the danger and had a chance to fix it.
Exactly. And that's why documentation is so important for both landlords and tenants.
Right.
Landlords should keep detailed records of inspections and repairs, and tenants should always report any potential hazards to their landlord in writing.
Got it. So it's a two-way street. Everyone needs to be doing their part to document things.
Exactly.
This is all so insightful. I feel like we've barely scratched the surface of premises liability, but I'm already much more informed.
Right.
And what's great is we have more time to dive into all of this. So to our listeners, stay tuned for part 2 of our deep dive into premises liability, where we'll unravel the mysteries of insurance and equip you with the knowledge you need to protect yourself should you ever find yourself in one of these situations.
I can't wait.
It's going to be good. All right, welcome back to the deep dive. We're continuing our exploration of premises liability, and I think it's time to tackle a topic that everyone has, but no one really wants to think about until they need it.
Yeah, insurance.
Insurance, exactly. It's like this mysterious document we file away and hope we never have to use. But when it comes to premises liability, it plays a pretty critical role.
Absolutely.
So can you break it down for us? How does insurance actually work in these situations? Like, let's say I'm a homeowner and someone gets injured on my property. Does my homeowner's insurance automatically cover that?
So in most cases, yes. Your standard homeowner's insurance policy, it usually includes coverage for premises, liability claims. So if someone sues you because they got hurt on your property, your insurance company will step in to cover your legal expenses and any settlements or judgments that might come out of it.
Okay, that's a relief. I bet a lot of homeowners don't even realize they have that protection built in.
You're right about that. And it's not just for homeowners either. Businesses have commercial liability policies that do basically the same thing.
So whether you own a home or a business, you've got some level of protection there.
Exactly.
Okay. But what about from the injured person's perspective? How does insurance work if you're the one who's been hurt?
So in those cases, the injured person will usually start by filing a claim with the property owner's insurance company.
Okay.
And that's often the most direct route to getting compensation for things like medical bills, lost wages, any other damages they've suffered.
So instead of immediately lawyering up and suing the property owner, you try to work things out through their insurance first.
Right. It's usually less adversarial and can lead to a faster resolution.
Makes sense. But here's where I feel like things could get a little bit tricky.
Yeah.
You have to deal with insurance adjusters.
Yeah.
And they don't exactly have the best reputation for, being on your side.
Let's just say their job is to protect their company's interests, which might not always be the same as getting you the maximum amount of compensation.
Right. So what's the best way to handle those interactions? Any tips for our listeners who might find themselves talking to an insurance adjuster after an injury?
Yeah, absolutely.
Yeah.
First and foremost, document everything. Keep really good records of every conversation, every email, every letter you exchange with the insurance company. Don't rely on your memory. Get it all in writing.
So if an adjuster calls you and says, oh, yeah, don't worry, we'll cover that, get it in writing.
Get it in writing and be very careful about recorded statements.
Okay.
Insurance adjusters often ask for these early on, but remember, anything you say can and will be used against you later.
That sounds like a good time to call my lawyer.
Yeah, it's definitely a good idea to at least talk to an attorney before you agree to a recorded statement. They can help you understand your rights and make sure you're not saying anything that could hurt your claim later on.
It's like having an expert translator to help you navigate all that legal and insurance jargon.
Right, exactly. And another important point to keep in mind, insurance policies, they have limitations.
Okay.
There might be caps on how much they'll pay out for certain types of damages, or some specific situations might not be covered at all.
So even if you have insurance, it's not a guarantee that all your expenses will be taken care of.
That's true. And that's why it's so important to, read your policy carefully, understand what your coverage limits are, and talk to a legal professional if you have any questions.
This is all such great advice. It's really empowering to know that you don't have to navigate this complex world alone.
You don't.
All right, so we've talked about how insurance works, both from the property owner's perspective and the injured person's perspective. Right. But let's shift gears for a moment and talk about prevention. What can property owners do to minimize their risk of a premises liability claim in the first place? After all, preventing an accident is always better than dealing with the aftermath.
100%. And the good news is that a lot of premises liability accidents are preventable if you just take some common sense measures.
All right. Lay some wisdom on us. What are the essentials of a good prevention plan?
Well, it all starts with regular inspections. Property owners should get in the habit of checking their property for hazards on a regular basis, daily, weekly, monthly, whatever makes sense for their type of property.
So it's about being proactive, walking around looking for anything that could be a trip hazard, a slip hazard, a fire hazard, basically anything that could cause someone to get hurt.
Exactly. And once you find a hazard, don't just put it on your to-do list and forget about it.
Right.
Fix things, replace broken equipment, clean up spills as soon as possible.
So the longer a hazard sits there, the more likely it is that someone will get injured.
Exactly. And never underestimate the power of a good old-fashioned warning sign. If there's a wet floor, put up a sign. If there's construction going on, block off the area clearly.
Simple but effective.
Right. It's all about making sure people are aware of the potential dangers.
Okay. What else?
Employee training is another big one, especially for businesses.
Okay.
Make sure your employees are trained on safety procedures. They know how to spot and report hazards, and they understand what to do if an accident does happen.
So it's not just about creating a safe physical environment. It's also about creating a culture of safety.
Exactly. And this one should sound familiar. Document everything.
Of course.
Keep records of your inspections, your repairs, your employee training, any incidents that happen on your property.
So if a claim does arise, you've got the evidence to show that you were taking those steps to prevent it.
Exactly. You got it.
This has been so helpful. I feel like I'm walking away with a much deeper understanding of all of this.
Me too.
And you know what? Before we wrap up this part of the deep dive, I have one more question for you. How do you think technology is going to change the landscape of premises liability in the future?
Oh, that's a great question.
Yeah.
You know, I think technology is going to play a bigger and bigger role, both in preventing these accidents and in, figuring out what happened after the fact.
Okay.
We're already seeing, security cameras and AI-powered monitoring systems being used to, enhance security and detect hazards.
Oh, yeah. What about those smart sensors that can detect, like, leaks or temperature changes? That seems like it could be a game changer for preventing those kinds of accidents.
Absolutely. And think about, in the future, using drones to conduct property inspections or virtual reality to recreate an accident scene for investigations. I mean, the possibilities are really endless.
It's amazing to think about how technology might transform this whole area of law.
Yeah.
Well, it looks like we've come to the end of part 2 of our deep dive.
Yeah, but we still got some more ground to cover.
We do. We still have some interesting details to unpack, including some specific aspects of California law that you won't want to miss. So stay tuned for the final part of our premises liability deep dive, where we'll explore those California-specific nuances and leave you with some final food for thought. Welcome back to the deep dive. We're wrapping up our exploration of premises liability, and you mentioned some California-specific nuances, so I'm really curious to hear about those, because it seems like California always has its own twist on things.
You're telling me, so today we're going to dive into a legal concept that often trips people up. It's called California's pure comparative negligence rule, and it plays a big role in premises liability cases here.
Okay, pure comparative negligence. That sounds a little bit like legal jargon. Can we maybe translate that into plain English?
Absolutely. Imagine this. You trip on a loose rug in a store, but you were also looking at your phone and not paying attention.
Okay, so you're kind of at fault, but the store should have fixed the rug too, right?
Yeah, it's a shared responsibility kind of situation.
Yeah.
Now, in many states, if you're even 1% at fault for your own injury, you can't recover any damages at all.
Okay.
But California's pure comparative negligence rule is way more forgiving. It says, hey, accidents aren't always black and white.
Yeah.
Sometimes there's blame to go around.
So even if I was partly to blame for tripping on that rug, I could still sue the store?
You could, but your damages would be reduced based on your percentage of fault.
Okay.
So, for example, if the jury decides you were 20% responsible for the accident because you weren't paying attention, your compensation would be reduced by 20%.
Well, that seems pretty fair. It acknowledges that sometimes both parties messed up.
Exactly. That's the idea.
Sure.
It encourages both property owners and visitors to be careful and take responsibility for their actions.
Okay, so this is a California-specific thing.
Yes. Pure comparative negligence is the rule here in California.
Got it.
Other states have different approaches. Some have something called modified comparative negligence, which basically sets a limit on how much at fault you can be and still recover damages.
Okay, well, I'm glad we're in California.
Yeah.
Good to know the law has your back, even if you weren't totally blameless.
It does, but here's the thing. Determining the percentage of fault, it can be pretty subjective. And a skilled attorney can be super valuable in, presenting your case effectively and arguing for a favorable split of the blame.
So if you can convince the jury that the property owner was mostly at fault, you could end up getting a bigger chunk of the compensation.
Exactly.
It sounds like having a good lawyer on your side can make a big difference.
It really can. Now, while we're talking about compensation, let's discuss damages.
Okay.
What can someone actually get in a premises liability case?
Okay, so what's the potential payoff here?
Well, it really depends on how badly you were hurt and the specific details of your case.
Okay.
But in general, damages can include things like medical expenses, lost wages, pain and suffering.
Okay.
And sometimes they can even cover future medical costs if your injury requires ongoing treatment.
So it's not just about covering the initial bills, it's also about those long-term impacts.
Right, exactly. And in some cases, you might even be awarded something called punitive damages.
Punitive damages, what's that?
Yeah, so those are kind of like a way to punish the defendant for really bad behavior. They're awarded on top of the regular damages, and they're meant to deter similar conduct in the future.
So if the property owner was like super negligent or acted recklessly?
Exactly. Like if a landlord knew about a dangerous electrical problem but just ignored it, and then a tenant got seriously injured as a result,
Yeah.
the jury might award punitive damages to hold that landlord accountable for Yeah, that blatant disregard for safety.
Okay, so it's like a way to really send a message.
Right, exactly.
Wow, this is all so interesting. I feel like I'm becoming a premises liability expert over here.
Me too.
But before we wrap up our deep dive, I have one more question. What are some common ways that property owners and their insurance companies try to defend themselves against these types of claims?
No, they have a whole arsenal of strategies to try to minimize their liability, and it's good to be aware of these.
Okay, so give us a peek inside their playbook. What are some of the go-to arguments?
One very common argument is that the hazard was open and obvious, meaning that the injured person should have seen it and avoided it. Think of a wet floor with a big yellow caution sign.
Right, so if you slip and fall, they're going to say, hey, you were warned.
Exactly. Another tactic is to claim that the injured person was at least partly to blame for their own injury because of their own carelessness.
Right, and that's where comparative negligence comes in.
Exactly. They might also argue that they had no idea the dangerous condition even existed, and therefore they couldn't have prevented the accident.
Which, again, is why documentation is so important.
So important.
It protects both sides.
Yes.
Well, this has been such an enlightening deep dive. I feel like I've learned so much, and I'm sure our listeners have too. Any final words of wisdom before we sign off?
I think the biggest takeaway here is that knowledge is power. The more you understand about premises liability, the better prepared you'll be to navigate these situations, whether you're a property owner or a visitor.
That's great advice. Thanks so much for joining us on the deep dive.
It was my pleasure.
Until next time, stay informed, stay curious, and stay safe out there.
Call now 714-442-9741. Thank you.